Have you ever wondered what happens to someone's property after they pass away? If you've heard the word probate, but you aren't quite sure what it means or if it applies to you, you are not alone. Today, I'm breaking down exactly what probate is, how it works, and most importantly, how you might be able to avoid traditional probate. I'm Jennifer Nichols, the owner of J. Nichols Law. I help clients work through probate and find the alternatives they need to work through their situation. So, what is probate? Probate is the legal process for transferring a deceased person's assets from the deceased person's name to the beneficiaries or heirs as applicable. The court ensures their wishes are carried out if they have a will. If there's no will, the court uses state laws to determine who inherits the assets. It's a court-supervised process, which means specific legal steps need to be taken before assets are distributed to heirs or beneficiaries. Probate can become a long, hard process when the proper paperwork isn't in place before the transfer of assets. That is where probate can get complicated. For example, we have seen cases where a will was written, but the will didn't provide for an independent administration. This required us to go through a procedure called a dependent administration. This requires much more court involvement and is longer and more expensive. This is just one of many cases I've encountered where a poorly drafted will ended up costing beneficiaries time and money. Now, this might sound overwhelming, but don't worry, that's where we come in. We aim to make the process as smooth, cost-effective, and stress-free as possible. Sometimes there are alternatives available that are less expensive and less time-consuming than traditional probate. Traditional probate happens when there are assets to distribute and debts to settle. A court appoints an executor who is named in the will to handle everything. This person gets letters testamentary, which allows them to collect assets, pay debts, and distribute assets to beneficiaries. Traditional probate is necessary when there are outstanding debts or formal legal authority is needed to administer the estate. While this can be time-consuming, it ensures everything is done properly and fairly. Now, what if there's a will but no debts other than a mortgage on a homestead? In that case, a simplified process called a muniment of title might be the best option. This does not require appointing an executor or going through the whole probate process. It's often a faster and more affordable way to transfer property. The steps behind this process are fairly simple. We file an application to admit the will to probate as a muniment of title, have a hearing, and then order certified copies of the will and the order. The court order serves as the legal document that transfers title to the persons entitled under the will. A certified copy of the will and order will then need to be recorded in the county where any real property is located. It will also need to be presented to any institutions holding assets belonging to the estate. Now, if someone passes away without a will and an administration is required, the court needs to determine who the rightful heirs are. An application for judicial determination of heirship and an application for issuance of letters of administration is filed. This process is more complex and more expensive than traditional probate, but in some cases it is necessary. If all heirs agree and no minors are involved, the court may appoint an independent administrator with authority similar to an executor in a traditional probate. But what happens if there are minor heirs or if there are disagreements among the heirs? In that case, the court may appoint a dependent administrator who has less authority and must obtain court approval for many decisions. This makes the process longer and more expensive. I've seen a few of these types of cases, and they can get messy. In some cases, they can take years to complete. The best way to avoid this problem is to make sure your estate plan contains specific instructions and gives your executor the authority he or she needs to take the actions needed. This is a huge reason why having the right legal representation can make all the difference. For smaller estates, there are two other options you can use. A cost-effective alternative is called a small estate affidavit. If there's no will and the estate's assets, excluding the homestead and other exempt assets, don't exceed $75,000, this option may be available. It allows heirs to transfer title to assets without going through the whole probate process. Another helpful tool is an affidavit of heirship. This is often used to transfer title to real estate when there are no debts against the estate and there's no need for a full probate process. Two disinterested witnesses sign an affidavit detailing the deceased person's family history and property ownership, and it is recorded in the county's property records. This can be a more straightforward, affordable way to transfer title to heirs. As you can see, there are multiple ways to handle an estate after someone passes. The best option depends on your unique situation. We're here to guide you through the process and help you find the best path forward. If you have questions or need help navigating the probate process, give us a call to schedule a consultation. We're here to make this process as easy as possible for you. Thanks for watching, and don't forget to like, subscribe, and share this video with anyone who you think may find it helpful. Take care, and I'll see you in the next video.